There is a type of administrative demand called the National Security Letter. It appears in no jury indictment, carries no judge's signature, and it comes with a federal gag order that may never expire. It has existed in its current form since 2001, and in a single year, the federal government issued over 56,000 of them. A national security letter is a document the FBI sends to a company, a bank, a phone carrier, an internet provider demanding records on a specific person. Not criminal records, any records, call logs, browsing history, financial transactions, subscriber information. The company is legally required to produce them. No warrant, no subpoena, no judge in the loop at any point. The person whose records are taken does not find out. The company that received the letter cannot tell them. The letter arrives with a built-in order of silence. By law, the recipient is forbidden from disclosing that the letter arrived, who sent it, or what it demanded. There is no public docket. There is no case number you can search. From the outside, nothing happened. The National Security Letter was not born from congressional debate. It was buried in the Electronic Communications Privacy Act of 1986, a bill primarily about email privacy. The original language was narrow. It applied only to foreign intelligence investigations targeting suspected foreign agents, and it required a senior FBI official to personally certify the need. Then came the USA Patriot Act, Section 505. Passed in October 2001, 45 days after September 11th, with almost no floor debate on that specific clause. Congress expanded NSL authority in 3 ways simultaneously. They dropped the requirement that the target be a foreign agent. They replaced senior official certification with field supervisor certification. Anyone running a local FBI office could now issue one. And they extended the tool to counterterrorism investigations broadly defined. One clause, buried in a 342-page bill voted on in crisis, transformed a narrow Cold War instrument into something with almost no limit on its reach. The FBI is not the only agency that can issue them. Defense intelligence components can. The Director of National Intelligence can. The authority was written to expand, and it did. And the gag order does not require a court to impose it. It is automatic. It attaches to the letter before the recipient finishes reading. If a company wants to challenge it, they may petition a federal court, but the law instructs that court to defer to the government's national security certification. The FBI certifies its own necessity. No outside party verifies the claim. Remember, no one voted for this specific architecture. The combination of zero judicial oversight and automatic indefinite silence is not a drafting accident. It is a design. Here is what it looks like from the inside. A telecommunications company receives a national security letter. It is addressed to their legal compliance team. The letter identifies a phone number and demands every subscriber detail, every call record, every timestamp and location entry associated with it. The team must produce the records. They cannot tell the subscriber. In some cases, they cannot consult outside counsel without FBI permission first. A small internet provider in Connecticut, a man named Nicholas Merrill, received one in 2004. He wanted to fight it. He hired a lawyer and filed suit, but the gag order covered the letter's existence, which meant it covered the lawsuit too. He could not say in public that a case had been filed. He could not say his own name. For 11 years, he was legally barred from identifying himself as the plaintiff in his own case. The gag lifted in 2016. The authority that silenced him is fully intact today. Courts have found portions of the NSL statute unconstitutional. The Second Circuit in 2008 struck at the automatic indefinite gag mechanism. Congress amended the law. The amendments preserved the core structure, no warrant demands, automatic silence, self-certifying necessity, and added a judicial review procedure that instructs courts to defer unless the government's judgment is clearly erroneous. That threshold has almost never been met. You cannot repeal this through legislation either, because any legislator who moves to weaken NSL authority faces a question they cannot publicly answer. Which investigation would you have stopped? The security apparatus controls what information exists about its own operations. The people who could build the public case for repeal are gagged by the thing they want to repeal. And here is what the National Security Letter reveals about every other institution. The tools that survive longest in government are the ones that contain their own justification. An NSL generates no public record. No public record means no oversight hearing. No oversight hearing means no political cost. No political cost means the tool does not shrink, it grows. Every mechanism that operates in permanent darkness follows this same logic. The gag is not incidental to the power. The gag is the power. Silence is not a side effect of national security. Silence is what makes permanent, unaccountable authority possible. Once you see that structure clearly, you start noticing it in every agency exemption, every sealed proceeding, every classified annex attached to a law you were allowed to read. And here is the question no one outside the Bureau can answer. If the FBI has issued hundreds of thousands of national security letters since 2001, and each one carries an automatic gag order, and those gag orders are permanent by default, how many are still active right now? Not even the people they cover know the answer to that.